Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass, and we're talking about somewhat of a tricky issue, which is multiple accommodations under the Americans with Disabilities Act. Even as we were getting ready for this podcast, we were talking through this a little bit, and it's a difficult issue. Like, what are we talking about? Are we talking about when an employee has multiple disabilities? Are we talking about when they have one disability and they're seeking multiple accommodations for that? There's a lot of issues that can trigger some fairly complex situations under the ADA, and we just wanted to get a dialogue going about some of those things that we encounter regularly and that you as employers might be encountering as well. So here's kind of an example of what we're talking about when we're thinking through this question of multiple accommodations under the ADA. So client calls and says, hey, we have an employee who is required to do a good job writing, and they're not able to do it. They're not able to write in an effective way. They're not meeting the expectations as to when these assignments will be done. And when we sat down and talked to the employee about it, the employee indicated that they had ADHD that was impacting their ability to do their job. So the employer starts down the Americans with Disabilities Act accommodation process. They were working towards getting information from a healthcare provider. And then when the information from the healthcare provider came back, there was an indication that it was not just ADHD at issue, but also depression at issue. So then the employer came to us and said, okay, now we're confused. What are we supposed to do here? Because we thought we were heading down one path for the interactive process and accommodation analysis, and now we have to pivot and go down another path. What do we do here? That's one example of where we've seen this come up. We have another example that involves a lawsuit that we were defending a number of years ago, and that involved a law enforcement officer who appeared to be impaired in the workplace. There was a question about whether or not there was some type of prescription drug addiction going on, and that ultimately resulted in that employee's termination. There was a whole lot of facts in between there, but for purposes of this conversation, there was an adverse action, there was a disability discrimination claim, and when that claim came through, the employee claimed that really he was suffering depression, not prescription drug addiction. So that's another example of what are we talking about and what should the employer have done to make sure they were covering their obligations under the ADA. One last example from me, and then I'll turn it over to Jen and Doug to see if they're thinking about any examples or situations that they've run across that touches on this multiple accommodation complex situation that employers face. So we had another case that involved an employee who clearly was having a mental health crisis, and that resulted in an incident that involved a possible suicide attempt. And that employee, when they went on FMLA to get some type of mental health treatment, when that employee was gone, that employee's coworkers indicated that really it was a question of possibly alcoholism because that employee had a history of drinking on the job. So that is somewhat of a very complex and difficult situation for employers because in my perspective, anytime you're dealing with alcoholism, drug addiction, even prescription drug addiction, and then some type of possible mental health disability. Those are tricky issues to get through. So those are some of the things we want to talk through today to see maybe, what Jen and Doug are seeing too, and then maybe give employers some ideas on best practices for things to be thinking through if you face situations like that. So Jen, Doug, what are you guys seeing that makes you think through situations where you have questions about multiple accommodations?
I've seen some things that are similar to what Pam was just talking about, but to give a little different flavor, I've also seen a situation where, there was an employee who was kind of disappearing occasionally from work or taking a long time to transit from like one work location to another. And when asked about it, said that he was having some kind of like stomach issues that were making him have to go use the bathroom more frequently than normal. So they kind of started getting into that and asking some questions to figure out what the accommodation would look like. And then suddenly he was saying, well, actually, I think I have cancer. And then, looking into that. And so that's kind of another, I think, scenario, right, where you may have an employee that either has multiple diagnoses or maybe just a little bit of lack of clarity as to exactly what their diagnosis is, because they're still going to the doctor and trying to figure out what's going on, right? Like they're experiencing some kind of symptom, but they don't know exactly what the issue is. And I think that also can make things difficult for an employer trying to go through the ADA accommodation process, because sort of information is still coming in, developing, and happening kind of real time, really, in some of these situations.
Yeah, and I've had a few things recently where it's kind of this combination between maybe some kind of mental health or behavioral issues and also physical issues at the same time. So those things may be on, maybe the physical issues can resolve, maybe not. There might be time frame things going on. There might be issues where this employee is seeing different medical treatment providers that are not necessarily communicating with one another. All of that kind of throws a monkey wrench in what the employer is going to do about it. And I think what's important here to think about, and I think we should kind of go here, is that, whether or not the ADA applies, first you determine, is this a qualified individual, right? Which means they have a disability. But once you cross that threshold step, then what's important is what are the limitations on their ability to do the job. So, I think that we can get kind of bogged down in all the different issues that the physical and mental issues that the employee is having. But what we really need to do is kind of boil it down to how do whatever all these things are affect their ability to do the job. And that's what the ADA process is about.
Yeah. And that, if you've ever gone to any of our trainings or heard us talk, I would say hands down, the most important thing for the employer to make sure they're doing is to get that healthcare provider info if someone has indicated they need an accommodation. So maybe it doesn't matter so much, like what Doug says, as to, what is the disability? How many disabilities or limitations are we talking about? What really matters is that you're able to go through the accommodation process and you're able to get the info from the healthcare provider telling you which essential functions are impacted by this limitation, regardless of what the limitation is. If employers skip that step, or they try to just apply their personal experience or stereotypes or, their Google, search to see how this disability would impact a job, that's where you run into problems. So don't skip the step where you give the employee that reasonable accommodation letter and have them take it to their healthcare provider to help you figure out what are the limitations and what accommodations is the healthcare provider recommending? Definitely, I would say hands down, the most important step in the ADA process.
Yeah, and in a situation like this where you might have someone who has more than one condition, and like some of the examples we were talking about, I think what might be a little different, like in many instances, you'll give an employee the interactive process letter. They will go to a healthcare provider, and that healthcare provider will provide a response. In some of these situations we're talking about, it may be, like Doug was saying, that they're going to have to go to two different healthcare providers to get input to provide the most complete picture of what it is that the employer needs to know in order to then evaluate reasonable accommodations, what those might be, whether they exist, and so forth. So it might just end up being a little more complicated, a little more time consuming than quote unquote a simple ADA issue. And I don't mean to suggest that ADA issues are simple. They often are not. But I think the ones that we're talking about today are the more complicated ADA issues where there may be multiple different essential functions impacted in different ways because the employee has more than one limitation on their ability to do their job.
Yeah, and that can be hugely frustrating. I mean, that is something we hear from our clients is, oh my gosh, we have an employee who's not really able to do their job. They've told us they need help, so the job's not getting done in the way that we would like to see the job get done. That's costing us all this money. How do we speed this process up? And the answer is you really can't. I mean, I think patience, as Doug said, as we were getting ready for this, patience is probably the number one takeaway for employers is if you start to have one of these more complicated situations, it's going to take a little bit of time to maneuver through it. And like Jennifer said, if you're talking multiple physicians or healthcare providers involved, that can take a bit of time, and you're going to have to give the employee time to get that info. Definitely what you want to do is to keep pushing the process forward, right? Like not having big delays, like making sure, you're letting the employee know what the expectation is as far as getting more information or going to a different healthcare provider to get your questions answered. But it's going to take some time to get through the process. Even in a relatively straightforward single disability case, it takes time, always more than you think it's going to.
Yeah, and employers are never happy about that. Even when it's going to take 2 weeks, and if it might take a month or two, oh my gosh, that can create a lot of problems. So employers need to kind of have a plan for how to deal with that in the meantime. What maybe it might be providing some temporary accommodations. Well, we should definitely say that they are temporary accommodations while the process is ongoing, just to keep that employee working and keep the business moving.
And sometimes these are the kinds of things, just to flag this for some employers, I think this is another tricky thing. Like if someone does have, sometimes for some of the, mental health challenges or even some of the substance abuse related issues, sometimes the employee can't work for some period of time. And so employers may have to figure out, is leave for some short period of time the right answer? It may or may not be, and it depends. But, to Doug's point, sometimes that is the type of accommodation the employee is asking for and that the employer has to think about during that interim period where the information gathering is happening. And I do think those are among some of the more difficult situations sometimes, and where it's frustrating for employers because, if this process takes a long time, you could have an employee out of the workplace for weeks, maybe even months, and that can be very challenging. So I'll just say, again, not that's the right answer every time, but sometimes it is, and something that employers may have to think about in some of these more complicated situations.
We were having a discussion before we started this session about another frustration which goes hand in hand with this, which is what do you do when the healthcare provider info comes back incomplete? Because again, if we're talking multiple letters going to multiple providers, that's frequently another frustration and another situation that employers encounter. And we were talking about all the reasons that's a thing, and when you're talking about maybe newer providers, maybe it's a nurse practitioner, a physician assistant, a mental health counselor. Sometimes those providers don't really understand the ADA, so they don't understand why they're answering those questions or how to give good input, and that's a frustration too.
Yeah, there's very kind of different goals, right? And the employer's goal is to figure out how to keep this employee working and keep the business moving forward. The healthcare provider's goal is the health of of the patient. So
treatment
and treatment. So you often get these responses that are I guess non-responsive. They don't actually answer the questions asked, and it's kind of maddening sometimes because it feels like you've been really clear. This is the information I need, and then you just get something back that's like, well, here's how we can help this person. Well, that's not exactly what we asked. What we asked is can they do the job, and what accommodations might they need in order to be able to perform these functions of the job? Those are the main questions that are asked, and it sometimes takes a round or two, and it's hard to get in to see positions, And imagine if you have 3 that you have to see and present this letter to. I mean, it's not surprising that it can take a significant amount of time.
So whatever you do, don't give up. I mean, that's some employers are like, okay, they gave us this bad info. Now what? Well, unfortunately, the answer is you have to keep pushing back, right? Like, okay, you got to tell them, document it. We received your response. It doesn't answer the questions. We need you to take it back. We're giving you 2 weeks to do that. I mean, you have to give a reasonable time to the employee to get the info, but you are entitled to those answers. So even though it could be tempting to just be like, okay, we attempted, we didn't get it, moving on, you got to get the info. That's really necessary to close the loop. So patience on the healthcare provider info.
And I'll put a plug in too in terms of talking about best practices. And I know we've talked about this on the podcast before, but one of the things that really will help you as an employer, have a higher likelihood of successfully getting the information you need timely is having things like a job description, right? Because that's a very clear list of duties where, you as the employer or the employee or their healthcare provider can point to, it's these things they're having trouble with. So it kind of makes the question a little more tangible and real and can be helpful, I think, in moving the discussion along, focusing the healthcare providers on the type of information that the employer needs, and then getting the right answers. I also think it's probably a good idea when you're giving the employee the interactive process letter to have some kind of discussion with them, right? I mean, because not all employees quite understand the process either. I mean, they know what they're struggling with. They know a lot about whatever their condition is, but they maybe don't quite fully understand why the employer is asking for this information and what the employer needs to know. So having some kind of discussion with them to make sure that you're on the same page in terms of, why you're asking this, what you need to know, also may help. Because then when the employee goes and presents this to their healthcare provider, they can share that information along with the job description, hopefully. And all of that, I'm not saying it's a magic wand, but should help to make the process more effective and hopefully not drag on for a long time because people just didn't quite understand what was going on.
The ADA process is all about communication. So don't short circuit any communication. Make sure that everybody's aware what the expectations are, why we need the information, when we need the information, and frankly, what happens if we don't get it.
Yeah, that's a really good point too, because I do think sometimes, even though everybody knows it's the interactive process, you're supposed to be communicating, I think some employers get worried because they're like, oh my gosh, it's the ADA, I could draw a claim and I don't feel really comfortable, so I'm just gonna kind of handle this on the side as quickly and as, effectively as I can. And Jennifer's point's a good one. You got to make sure the employee knows what's going on and what's expected. We've seen many a claim from not great communication, right? If the employee thinks that they came to you with an accommodation request and nothing's happening, that could lead to a complaint of some type. So make sure you loop the employee in. That's a good point too. Okay, so we've talked about making sure you're able to figure out, even if it's through multiple healthcare providers, what limitations are we talking about? We talked about getting info from the healthcare provider. We talked about slowing things down. Even if it takes a while, you got to make sure you close the loop on those things. You got to make sure you get the info back and that it answers the questions you need. We talked about communicating with the employee, letting them know what's going on. I would add on here supervisor training, because if your supervisors don't know that these are possible ADA issues, they might not be getting flagged for you. So and I think supervisor frustration sometimes plays a role in this. Again, it's a process. It takes a bit to get it done, making sure the supervisors understand that, making sure they know they're keeping this confidential to the extent they can, making sure they're in the loop as well. And the interactive process does allow for that. You can't have the whole workforce knowing what's happening, but the people in the need to know group, which would be the direct supervisor of the employee, they're certainly entitled to know what's happening so they understand what's going on and they can actually participate when you get that info back and start talking about accommodations. So training, don't forget training. I would throw in there for some of these really complex issues like the alcoholism, prescription drug addiction. Anytime you're talking impairment in the workplace, I get nervous. Like those are going to take some thought and some analysis. Call counsel for those. Don't try to, ease your way through it intuitively. That's not a good idea. Those are dangerous, complicated issues. And there's other possible tools that could come into play with those too, like fitness for duty, right? Like, if we're talking law enforcement or heavy equipment operators, there could be some other ADA process that might apply. But again, I wouldn't try to work through those without counsel because those are we got a lot of case law that tells us what needs to happen for those to take effect. So those are some pointers to push you in the right direction. I think we're seeing more and more of these complicated ones come in the door that involve multiple things, multiple issues, layer on layer of possible limitations. So big takeaway, get some counsel, get some education, get some training, and be patient on that. So my last thing I was just going to mention, we've got our Law for Leaders book, and it's got multiple chapters. It's got multiple chapters on this exact issue. It's got chapters 8, 9, and 10, which talk about ADA scope, and then we got an alcohol and drug addiction chapter. We've got a mental health and complex issues like suicide. Those are tough issues, very, very tough, but we got some good guidance you can keep on your desk with our Law for Leaders book. We got a training coming up on September 25th on workplace investigations. If you're interested in that, check that out too. And otherwise, we'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.